Morning, everybody. Welcome, and just very, very pleased that Advocate Helen Fent is joining us this morning to really go through a particular court case which was decided on Friday or published on Friday, Mbambisa and others versus Nelson Mandela Metro. And this is a Supreme Court case. Let me just see if I can share this. And then we're gonna ask Advocate Fent to just take us through this. Now, for those that don't know, Helen, can I call you Helen, or would you prefer Advocate? Okay. Helen is an advocate, and she's been advocate of the Supreme Court as well, and she is very accomplished, very experienced, very respected in her understanding of public procurement law, with a particular emphasis on local government. And I've got to do a little I was privileged to co-write a textbook with Advocate Fent, with Helen, and just learned so much from her. And she was the first one to alert me to this particular case that came through. And so, Helen, just welcome and thank you very much for joining us. All right, so there we are. You're unmuted and you can talk at any point now. So this is a Supreme Court of Appeal judgment. Mbambisa and a whole range of appellants that are there. The company concerned is R7.5m, I believe, and it's the Nelson Mandela Bay Metro, which is the respondent in this particular case. So, Helen, do you want to just give us a bit of a summary of this particular case, or background to this case and the outcome of it, before we get into some of the implications? Let's just understand what this particular case is about.
Okay, thanks, Sean. If everyone can hear me, yes. Maybe just before we get into the meat of the case, being a Supreme Court of Appeal judgment, as our judicial system work in this country as per the Constitution, it means that this judgment then applies to the country as a whole, unless it's superseded or changed by the Constitutional Court. So what is important for us as officials then to know is that this is applicable to all of us, the outcome and how the court has interpreted the law. Then just to give you a little bit of background, the matter, it seems, originated already in 2014, and it relates to a integrated transport system for which National Treasury has granted, I think, over 6 billion rand of grant funding to the Nelson Mandela Metropolitan to implement this integrated network system. And they have then, as part of this grant funding, appointed R7.5m to assist with their marketing and branding. And it appears, if you read through the evidence, that it was like a whole comedy of errors. There was a submission for deviation procurement, which was not supported by some officials. Then the appointment did go through, payments were made, and then the appointment or the contract was further expanded with additional payments, close to 1 million that was made. So in the end, I think they paid close to 9 million to this company. And there was a forensic audit done by Deloitte via the National Treasury. And then based on this forensic report, the municipality then took the matter to the High Court with the request that the contract be invalidated and that claims be instituted against the company, but also certain officials within the municipality for deliberately incurring irregular expenditure. The High Court then looked at the matter and basically confirmed that the appointment was unlawful and that payments have to be, or penalties have to be imposed and recovered from both the company and the officials jointly and severally. Some of the orders of the High Court then appear to be a little bit duplication, be a duplication in nature, because it says the officials need to pay the money, but then Erastyle also needed to pay the money. So then the matter was taken to the Supreme Court of Appeal, where some of the officials and Erastyle then said, no, this judgment is wrong. Not just on the order of payments that's due, but also that the court interpreted the law incorrectly. That Section 32 relating to irregular expenditure and recovery of irregular expenditure cannot be read in isolation. It must be read with Section 176 of the MFMA. And those of you that have the MFMA at hand, if you read it, then you will find that Section 176 of the MFMA basically says that the municipality and the officials, if they act in bona fides and there's losses suffered, they are protected from that. But what the court then said, just to give you context, is then the court said, but that only applies to third parties in the one hand, and secondly, it only applies where the officials acted in good faith. But 176 also then says that where the officials acted in a deliberate way or grossly negligent, the losses may be recovered from them. And that's how we have applied it in the country as a whole all these years, is when an official deliberately or grossly negligently incurred irregular expenditure, it was recovered from that official, but only the losses or damages. And in this judgment, the court now said, no, that is not relevant to 32. The language of 32 is very clear. It's not related to damages or losses. It's related to a penalty. So if an official deliberately or grossly negligently incurred irregular or fruitless and wasteful expenditure, as a penalty, the money must be recovered from them. And that do pose a lot of questions for us now in interpreting this act and applying this act then, because basically what it now says is, if this matter, if any irregular expenditure or fruitless and wasteful expenditure is investigated and it's found that there is a true irregular, fruitless and wasteful expenditure, and it is found that any of the officials is liable for that expenditure, meaning that they deliberately or grossly negligently permitted or incurred that expenditure, the full amount can be recovered from them. So that is the gist of the case. I don't know if you want me to get into my personal feelings and opinions and thinking and what I've heard, but
let's
just to give you background.
Pause on that. Thank you, Helen. So in this particular case now, before we get into your feelings on this and your suggestions on this, so the Supreme Court of Appeal, what they denied the appeal, is that the wording, and basically then confirmed that the individuals concerned have to pay.
Yes.
And it's quite a lot. If I can just quickly jump to the back end here, it's quite a lot.
There's three different ones. I think it's 5.2 million, 1.3 million, and then close to 1 million.
5.2, 1.39, and then 1 million, plus interest as well, I think somewhere I saw. So
yes.
So these individuals now have to pay this. Now, they're confirming that these individuals were guilty, and this money was wasted, and therefore this was this wasteful expenditure, or was this irregular expenditure?
I think in this instance it was irregular expenditure.
Irregular expenditure.
Just want to make sure that they did confirm.
And okay, so these individuals, and I seen in various cases and articles and things, these people were guilty and they've resigned and they've left, and so they probably are guilty and they probably do deserve this. Probably, I don't know. But that's really what the Supreme Court of Appeal now has said and confirmed. What is their options if they were to disagree with this? Do you think this would go to the Con Court, or do you think this is it? Because that typically would be the next step, right? Is we're unhappy with the Supreme Court of Appeal decision, and let's take this to the Con Court.
Well, if the officials have big enough pockets to do this, obviously the municipality got what they wanted, so they don't necessarily want to go to the Constitutional Court. What I most probably see would happen is that based on the implications of this case, it may be necessary for the custodian of the law, which most probably is, well, which is National Treasury, to may request the court to give a clarification order on interpretation.
Okay.
Because as it reads now, I think what will happen in practice, and that's where I'm concerned about alarmists using this case, is it seems as if you read the case on the face of it, it seems as if there's any irregular, fruitless and wasteful expenditure and any official's name is attached to it, that official will be liable for those costs. And that is just what is my concern with this case. I don't necessarily disagree with how the court interpreted the law. My concern is just that the court may not necessarily consider everything in terms of the law. And I've seen now some of the chats that popped up, and specifically the question, is it negligent or grossly negligent? I think I'm showing my age, whoever asked that question, because previously in the old government, when we talked about state liability, we talked about grossly negligent, but it's negligent. If you read section 171 of the MFMA, it says if an official negligently or deliberately incur an irregular, fruitless or wasteful expenditure. But what is missing in this judgment is neither the advocates that submitted the case to the court and neither the judges in the court considered the determination of liability. And that is where my concern is with this judgment, is there's still a process that you need to go through. As soon as an irregular or fruitless and wasteful expenditure is identified, a process must be followed, which I think these days call consequence management. And as part of your consequence management, you need to determine liability of the officials. And to determine liability, in my view, you need to follow section 171 for municipalities, 172 for municipal entities, to determine that liability. So there must be some evidence that the officials acted negligently or deliberately in incurring this expenditure or permitting the expenditure to be incurred. And that is my concern with this judgment, is it's silent on that. So if this judgment is read by, say, for instance, MPAC members who are not lawyers and who are not necessarily government officials or understand the workings of government or understand how the employment legislation in government works, but on the face of this judgment, it may appear that all officials are now liable for these expenditure that's being incurred.
And is it fruitless, wasteful, and irregular expenditure?
Yes, I think it could
even I think it's all three of those, and that was one of the issues on the...
Even unauthorized.
And
so it's unauthorized, irregular, fruitless, or wasteful expenditure. So it's all three of them. If an official deliberately or negligently permit or incur such an expenditure.
Now, you mentioned 171. 171 is not even mentioned in this case.
No. And that's my concern. And not even 173 that deals with financial offenses. And that's just, as I say, for me, this is the big gap in this judgment. And for officials that read this and hear people talk in the corridors about it. That's what I wanted to caution you, is just if someone wants to raise the alarm, just mention to them that, remember, we first need to determine liability. It doesn't mean if you've signed an irregular expenditure, you're immediately liable for it. And why I'm saying these things is because we know we all sit with legacy contracts that the AG declared irregular, that we had to honor. Those contracts were not invalid per se, unless you take it to a court to invalidate the contract. So now we're sitting with irregular contracts that we do pay because we do receive those services. And the concern is now, okay, I've paid, but we know it's an irregular contract. Does it mean I'm now liable for that?
And if it's an irregular expenditure, they're liable for the regular, although the institution did not suffer a loss.
Exactly, because that's how it's that's how the judgment is reading at this stage on face value. But what I'm saying is, or cautioning the officials, is if someone wants to apply this judgment, just remember you first need to go through a due process to determine liability.
Right, right. Is that a court process, Helen, or is that something that happens within the institution?
No, we call it, I suppose, in admin terms, we call it a disciplinary process, but it's a labor process. You follow a consequence management mechanism, you do an investigation, you identify officials that could be potentially liable, you then go through a financial misconduct process to determine if they're liable. But the main thing we need to remember, what this judgment now says, is that if an official is found to be liable, the money can be recovered from that official, irrespective of any other disciplinary ruling against that official. But basically, the court says there's no discretion. Once you go through a process and you're found liable, this money must be recovered from you.
Okay. Now, Helen, what about statements in PAJA, for example? I mean, I'm aware of the one that says that an official cannot be held civilly or criminally liable for anything done in good faith. Is this contrary to that statement in PAJA? How does one rationalize that?
Well, in my opinion, and I'm sure we can ask the broader audience as well, their opinions on it, is the operating word is bona fides or good faith. If you acted in good faith, then you did not act negligently or deliberately. You acted in good faith. So, but it all depends on how we apply those definitions in our consequence management mechanisms and how we apply those definitions within our labor processes or disciplinary processes. If I can use a practical example, for instance, the MFMA also says that you need to pay suppliers for services rendered within 30 days on the receipt of an invoice. So that's also an MFMA requirement. So now I've received an invoice for services rendered. It was declared an irregular expenditure on a technical error. Say, for instance, a page of the tender document was not initial.
Right.
But the services are being rendered. The contract is not invalid, the contract itself. It's just the expenditure that's irregular.
Yeah. They've received
now in terms,
yes.
Now in terms of the MFMA, you must pay when you receive an invoice, even if the expenditure is irregular. So now you're sitting in this damned if I do, damned if I don't situation. So now I do pay for the services that's been rendered, but I do make a note and indicate, but remember, this is an irregular expenditure because of this and this and this. But basically, it could be argued now through a disciplinary process, but you deliberately paid. You know it was irregular and you still pay. So how do we deal with that? And again, I'm coming back to those legacy contracts that we have. And we're talking about like housing contracts, which are hundreds of millions of rands worth. And remember, if a contract is found to be, the expenditure is irregular, it doesn't automatically mean the contract is irregular.
Correct, yeah.
To determine if a contract is irregular, a court needs to determine that. So that means if you read this judgment on face value, and I've already received calls from officials and other clients of mine that says, you know what, Helen, all our irregular expenditure, we're just not going to pay. We're going to tell the people, take us to court.
Yeah.
Because we can't confirm, we can't pay an irregular expenditure because we will be liable. And that's my concern in interpreting this judgment.
So the public sector, local government comes to a halt.
Basically.
Yeah, yeah. Okay. So you said up front that what then should happen was that National Treasury, the lawmaker in this case, needs to go to the Supreme Court or the Constitutional Court and ask for clarity, probably Supreme Court, and ask for clarity on this.
I think it would just give more guidance to all of us in the country, but I'm not sure if they would do that. And looking at, just from Lindiwe, the note that Lindiwe is making is, I fully agree with her, is I do think if we look at this judgment, I do think that the advocates, or basically all the lawyers in this judgment, failed in their responsibility of considering proper evidence and putting proper arguments in front of the court. Because you will read, if you go through the court, that in certain instances, they didn't even call witnesses. They just didn't put a case forward. They just expected the court to rule on it. And I think that is where we have a gap in this judgment, that certain important elements were not considered. And now we leave it up to the interpretation of the institutions in how to determine this liability.
And the simple interpretation will be pay back the money.
Yes, but I just want to clarify this. I'm not talking here because in this judgment, it was clear that the officials acted in bad faith.
Yes.
I'm not talking about corrupt officials here. I'm talking about in the general run of the mill of things where an innocent error was made and a contract was, or an expenditure was declared irregular. Where officials deliberately abuse the procurement system. In that regard, I think they should feel the full arm of the law.
Correct, yeah. It's where they're still acting in good faith, and they're receiving the value and the services have been done, and that's where it becomes a little bit difficult. Brian is just asking about condonement. I mean, could that be a way to manage this?
It's a really good question, and sorry guys, why I'm laughing is I'm assisting quite a few municipalities in addressing audit COMAFs, and as I said, I don't want to abuse this forum, but it's a very good question in the sense that I always inform officials, please read the definition of irregular expenditure. Expenditure is only irregular if it's not condoned. So how can you change your financial statements and increase your irregular expenditure or disclose your irregular expenditure amount in your notes on a finding of the AG if you have not been allowed to first request condonation from Treasury? So that's just on irregular expenditure, a comment I would like to make. So to respond to the question, Brian, yes, obviously you can approach National Treasury to request condonation in terms of Section 170 of the MFMA. And if you read the section, it says on good grounds shown. So if it was an interpretation that's always been applied, it's applied across the country. It's not just one person's interpretation. If services are rendered, if it was done in good faith, if no losses are suffered, if value for money is received, then according to me, you will have sufficient grounds to request condonation. If National Treasury will grant condonation, that I cannot tell you. That is up to them again to apply their discretion. I'm sure, is that the base of the question? I'm not sure if I'm responding to Brian's.
I think it is. But if we take your example of you've now received an invoice from a supplier who has delivered the service, however, this particular transaction at some point was declared irregular. So do you is there some way that you can approve payment and request condonement immediately before it becomes an issue? Is there some way we could get around this somehow so that we don't stop the whole process?
I hear you. There, I suppose I can give some clarity, is that the National Treasury's interpretation of condonation is they condone the non-compliance with the Act. They do not condone the expenditure.
Got you.
So if a contract, a whole procurement contract is declared to be irregular,
yes,
then the condonation that Treasury will give is for not complying with, say, for instance, Regulation 32.
Yeah.
But they will not condone the expenditure.
Got you.
But once they condone the non-compliance, then the expenditure immediately is regarded not as an irregular expenditure.
It's no longer
because it's not. Yeah, the definition says it's only irregular if it's not being condoned.
Right. So is that the whole process we're going to have to follow now?
Well, I think what we need to do is, if I was still working in a government institution and based on this judgment, I would go back to my consequence management mechanism, policy, whatever we have, and I will review it to make sure that we are very clear on how we determine liability. And yes, and if I can read, I think it is under note 56 of the judgment. The court defines it, or basically says that liability arises as soon as an official intentionally or negligently incurs unauthorized, irregular, and fruitless and wasteful expenditure. Okay, and then it just says that Section 32 is not conditional upon a municipality sustaining loss or damages. So that for me is the most important element of that judgment, is that do not forget that we first need to determine liability. And to do that, you need to follow a process. And that is where, and I must say our legislation in this instance, in some instances, contradict each other. The labor portion and employment portion of legislation versus the MFMA or the PFMA is not always that clear. And there's not a clear alignment between them. For instance, I had instances where irregular expenditure was incurred, a disciplinary process was followed. The presiding officer then ruled that the official was liable, and he gave him a final written warning. We then said, in terms of the PFMA, we now need to recover the irregular expenditure from him. The official immediately then said, unfair labor practice, double jeopardy, you can't give me 2 sanctions for 1 error. So there's a lot of other things that also now poses questions. And the next one is, okay, so in terms of the MFMA, you're going to recover the money, you didn't suffer a loss. So from the civil law civil law side of things, I will now institute a civil claim against the municipality for undue enrichment. Can you do that? Is that now an option? So those are all the questions. I don't have all the answers. I'm just saying is that this judgment poses more questions than solutions.
I see that Gloria raised her hand. Gloria, if you want to ask the question, welcome to. Well, let's just see if Gloria there. Gloria, hi, welcome.
Well, thank you, Sean. I think I've seen the judgment just in passing. I didn't read, but having been the official or an auditor within the government departments, one of the key things that I always argue about, it's what has been said just now, that I think the officials and department are not paying attention to. That being the manner in which an expenditure is declared irregular. We fought, I remember, I will just make an example. At some stage, I was in Parliament, and we had a long argument with Auditor General, where they declared some expenditure as irregular. And having been the auditor there for the institution, the expenditure that they declared as irregular was not irregular. So that's what the argument was within the audit committee, that this irregular expenditure is not irregular expenditure as it is defined in the legislation. So the officials, what I'm trying to say, it is right to say the officials must fight the battle there first, so that whatever is declared by Auditor General as irregular, it is really irregular.
Mm.
Because if it has already been out there to say Auditor General is declaring this expenditure irregular, you can't fight. You'll fight a losing battle. Then there must be a determination of liability. That has been my argument as it is raised there, is raised here. That firstly, before it is regular, there must be a liability. You don't just put it there, because the reason is that when it is declared irregular, there must be that process, but the process is reactive. And now you can't argue because you've got, I'm saying this from the practical experience, because you've got the integrity of Auditor General, that you're saying Auditor General's processes were not good enough, and then if you attack, you are seen to be attacking a Chapter 9 institution, then it's a crime, and there's so much. So in this, without making it long, my advice would be the officials and the accounting officers should be vigilant during the audit time to say whatever is declared irregular. I always say to people that I talk to about this, there is so much that as an auditor within the government department that I can challenge that is not irregular. Let me just conclude by saying one of the reasons in discovering whether the expenditure is irregular or not, where Auditor General automatically declare an expenditure regular, when you have one supplier say, they will say it's not competent because there were no 3 quotations. And in one of the expenditures that we challenge is that there was proof that the institution tried to get 3 quotations, because the institution doesn't have the power to cause the suppliers to submit quotations. And the suppliers were complaining that the reason that we're not supplying providing our quotations is because we don't get the tenders, and we spend a lot of money, and then the institution is ending up with one supplier. So even then, if you look at it, there's so many complications.
I think, thank you, Gloria. I think we've got the gist of it. Helen, any thoughts on Gloria's points?
just to say that I fully support what Gloria is saying, is that firstly, I know we have this thing, and especially during this time of the year now where we're busy with municipal audits,
Yeah.
that, you know, everyone is so tired. So most of the
Yeah.
times they just don't fight anymore. They just accept it, and as long as it doesn't affect the clean audit. But my concern is we should start being more strict on not just accepting findings of irregular expenditure. And it remains my view that if you read the legislation in context, what should happen in practice is as soon as the AG identify an irregular expenditure, and an organization has a consequence management policy or mechanism, then what should happen is the municipality should then say, thank you, we acknowledge it, we will register it, we will now follow our process, we will investigate it, we will determine liability, and if we find it to be a valid irregular expenditure in the next year's financial statements, we will then put in a corrective note under the disclosure notes. And it remains my opinion that we cannot, within a matter of 5 days, say, AG, we accept this irregular expenditure, and then just accept it as is, especially as in most instances, it deals with interpretation of law.
Yeah.
And for me, interpretation of law can only be guided by the custodian of the law, which is National Treasury, or by a court.
Yeah.
It's not the institution's mandate, and it's not the AG's mandate. It could be that it's their opinion, which I don't disagree with, but it must be tested. And so that's why I agree with Gloria. We should have a mechanism or a process. And if we can maybe just get National Treasury to support us in guiding us and saying, this is a proper consequence management mechanism to apply, and we apply it across the country.
Yeah, yeah. Thanks. Just before we go to Dalil, Helen, what is the applicability, the lawful applicability of this judgment on PFMA institutions? Is there anything?
On the liability of law? Sorry, I missed your
The
question.
outcome of this. So the outcome of this is very, very much based on
MFMA.
MFMA. We've
The
got
PFMA
online,
used the same wording.
We've got a lot of PFMA.
Sorry, guys, I'm just getting my law. Okay, got it.
And if I'm not mistaken, I think the PFMA wording is different in this. I think it is. But even if it was similar, what do you think? Do you think or is that something that we need to consider separately? I know this is very new.
I'll have a look at it for you, and maybe I can just offline, because I don't want to waste time in this meeting on it. But you know, Sean, when I dealt with irregular, fruitless, and wasteful expenditure in PFMA terms, when I still worked at the Provincial Treasury, we've already started raising this. That in terms of the Act, you need to recover. But in terms of the labor legislation, after following a disciplinary process, it does not have to result in a financial or a penalty to be paid situation. So I think it would be fairly similar. But if you're okay with it, I'll work through it and get back to you formally.
Yeah, I mean, I just was going through, and I see there's a lot of PFMA people online as well, CFOs and others that are online today. So that would be an interesting question. My thought was that this would not necessarily apply, but I think that that probably needs to be looked at carefully.
Yes.
Dalil, welcome. You can unmute and pose your question. Let's jump. Chad Phillips, you raised an interesting point in the chat. I wonder if you can unmute and maybe just expand on that a little bit, Chad.
Sure, thanks.
There we are. Go ahead, Chad, and we'll come back to Dalil. Go ahead.
All right, thanks. Sorry to steal Dalil's term. So I just wanted to find out a Counsel, you said something very interesting in relation to whether or not somebody would be able to go by way of unjust enrichment. If we're then looking at the liability that the Act itself creates under Section 32, sort of as a res ipsa loquitur, if we're then looking at a determination of quantum, if we're getting in front of the court for them to recover that, the quantum ultimately would be zero if there is no loss that is suffered. So as much as there is liability, is it also imposing, or the wording of this judgment, is it also imposing the quantum as opposed to just the liability?
In my understanding of reading the judgment as it is, it basically says the full amount of what is regarded as being irregular. And in terms of current interpretation by, I think, the AG and National Treasury, the whole contract value would then be recovered, even if services were rendered. I'm not sure if I understand you correctly, Chad.
Yeah, no, that's where the question was going. It's going to be very interesting, to say the least.
That was one of, I suppose there's a one-liner in this judgment where one of the advocates raise it and say it will be an absurd situation because now you unduly enrich yourself. And that's when the court turned around and say, but in this instance, you don't claim damages. It's a penalty provision. And that's why you will recover the money. But yeah, it's it's an
I think there's going to be a lot of vacancies in the local government.
Well, as I've
space.
said, I've received calls from municipal managers, CFOs saying either I'm not going to approve any expenditure that's currently part of irregular contracts, or alternatively, I'm just going to leave. I'm not going to work for government anymore. I can't take this risk.
Okay, but we don't want that
for a fact. Sorry, Sean, one final word. I know that there are municipalities currently that will only pay against a court order. So yeah, you're not far from the truth.
Yeah.
Yes, and reality-wise now is our courts are already inundated. What will now be the flip side? You will go to court to recover the money from the official, and the official will immediately institute a counter civil claim against the municipality. It doesn't make sense.
Yeah. Let's jump to Dalil. Hi, Dalil. Thanks for that, Charles.
Hi, good morning, Sean and colleagues. Yes, my little
go ahead.
colleagues is just, can you hear me?
Yes, we can.
Yeah, I just want to from a different angle. I think I wanted to latch on what Laura was saying. I think colleagues in our SCM regs, the word must, it appears nearly 150 times, I think 147 times. That becomes the rules of engagement. So when the auditors audit us, the first audit us to non-compliance to laws and regulations. There's nothing in any, if you look at the definition of irregular expenditure that has incurred. Now, all over the years, we had all the fights in terms of those two concepts. But I fully understand and appreciate the whole thing of we must determine the liability. But I think with that also, I think we're going to argue on our side, we must also determine the whole tree of negligence. Because if all of us knows now that there's 150 times that the word must appears, it means that we have, as authorities, need to do a lot of things to get that in place. Because in the practical implementation of and service delivery, there's a lot of times that we know, you know what, we are acting in good faith. And I think what worries me is that this whole thing of Section 32, it's a statutory claim, it's a penalty and not damages, it's on the jurisdictional requirements, we are statutorily obliged to recover and valuable money, and we have not really done us any loss in terms of surplus. State is not relevant now. So that is more my thing, and I think there need to be, if there's colleagues that work on that levels of National Treasury, maybe just to review again MFMA Circular 68, because the purpose of that circular was to provide clarity on unauthorized, irregular, and fruitless and wasteful expenditure. Yeah. So that's my 2 little cents. So thank you, colleagues.
Thanks, Dalil. Helen, any thoughts?
For me, the ideal would be if we can align the Section 32 process with the whole consequence management, financial misconduct mechanisms, that they're all combined in one singular process that gives clarity. Because if you read Circular 68 at this stage, it's more to do with how do you deal with the treatment of the irregular and fruitless and wasteful expenditure and unauthorized expenditure. And it's more from an accounting perspective. It does not necessarily align to the labor side of it, which is covered through the financial misconduct regulations. So for me, we need to marry the two and rather have one set of clear guidance. And this now from a municipal perspective, but obviously it will apply to a PFMA perspective as well. I think PFMA is even more difficult because the Public Service Act definitely have certain provisions in that is directly contradictory to the PFMA requirements on financial misconduct. And I know that they've been trying for years now to amend the legislation to be complementary, but it hasn't happened yet.
Thanks. We'll come just now to the implication of this under the Public Procurement Act. But let's jump to Mpilo, and then I'm going to ask Agrippa Mpongose and Adine Abro, any other lawyers that are online, if they would like to share any perspectives as well. I know that for every lawyer we've got a different opinion, but so you're welcome to come in and just share your perspectives as well. Mpilo, go ahead.
Thanks, John. Mine is not very much a legal technicality, because I'm in the labor relations space. But all I'm looking at is that people we seem to be very defensive, instead of looking at probably what do we need to ensure that we don't get into this situation of this irregularities that are concerned. I think there's somebody who said initially that you needed an internal auditor that will help you navigate these particular challenges, instead of being so defensive, because people are now talking about, now I'm going to leave my job and all that, instead of saying, how then do you ensure that we don't get into those waters, those torturous and treacherous and treacherous waters of irregularity. Because if you've got an internal auditor, he or she can guide you in terms of how do we do this correctly. And even in this case talks about mala fides, mainly mala fide intention, not bona fides. When there's a finding that you are bona fide in your action, then there would be no consequences. It now looks like everybody is looking at it from a mala fide perspective, not necessarily to say, if you were correct in doing whatever you're doing, and those consequences came out of, there might be a slight oversight on something else, then you get into this particular challenge. So people then are starting to talk about it as in a form of a defensive situation. So I think for me, I'm taking it in a progressive light in terms of say you need to be extremely cautious and careful in your implementation of whatever you want to implement in government. Thanks, Sean. Thank you.
Thank you. Good. Sounds like he's agreeing with you there as well on the importance of the labor aspect in this, Helen.
If I may, I know you want to get into the Procurement Act. I think the easiest solution would be for all of us if National Treasury can amend the MFMA to distinguish between technical irregularities, administrative irregularities, and deliberate and negligent irregularities. And if the AG then classify their findings accordingly, it would be easier to manage the process.
Yeah.
And even the perception of the citizens out there when they read our financial statements, that they don't think all irregular expenditure means we all corrupt. And as I say, where I'm coming from is on behalf of the good officials, those that do act with good faith. Mala fide officials, they must get what comes to them.
Got you. Agrippa, any thoughts? Anything to add? Adine, anything?
Good morning, Sean, and everybody else.
Welcome.
Thank you. Fascinating judgment. What I'm hearing is what I believe the very reason, and I know we're going to talk about it, but what I believe is the very reason why we have this new Public Procurement Act. We are talking about things like clearing up and interpretation difficulties and that sort of thing. And I do believe that this act, which allows us to regulate, I'm coming from a construction background, but that allows each industry to regulate and to then tie in with the PFMA and the MFMA and all of those sort of good things. I think rather than going through the courts, which Advocate Fenter has also mentioned, is a long, laborious, time-consuming exercise that will leave us in the dark ages, or we will continue to remain asking ourselves these questions. You know, it's just unbelievable that the court process, we have some fantastic judges, it's just too slow, and these things need to move forward. So I think that I see this judgment in a positive light for what it does give, but it also shows us that we ought not to continually rely on the court's judgments to come to an understanding of things which are not particularly covered, but see where we can include certain interpretation issues or difficulties we have with judgments as part of regulations under the new act. I think it's such a useful tool if we can do that, and that's my 2 cents worth.
Thank you, Aline. I see also Advocate and Salubas here. Also welcome to put your perspectives in as well.
Thank you, Sean. I could not comment on your channel. It's quite an interesting judgment, especially having been in that space where you have to, at the time when you are dealing with findings, and you must indicate how are you dealing with each and every irregular, fruitless, and all. Suffice to say, Sean, I'm not being prophetic, but for me, it's making a call on when would you allow or agree to be part of the audit committee, because it means using the Companies Act, the level of due diligence the stakes are higher. But then I would switch it the other way and say it then calls for specific capabilities when people get accepted into those roles. That's one. The second one, though, which is painful for me at least, is then the role that our officers, the position our officers are placed at. And I'm saying this with all the humility, because you find that our officers at some point are forced to operate under certain pressures. I will leave it like that.
Yeah, exactly.
And because of I'm speaking as a person who has been in the battlefield. And because of that, and I think it's high time that we make sure then that the professionalization of this particular capability or sector happens, because then when you read it through, yes, it has some elements. For example, for me, it linked so much with the latest amendment that was in the Public Audit Act, which was following on what has happened to fruitless, what has happened to irregular, which was about to be implemented. But I think regarding the officials themselves, And I mean, with the audit committee, you chose to be part of the audit committee, but I'm saying there's a deeper due diligence that must be done. And also, when then you sign into the actual agreement, must spell out those things because the stakes have changed. But lastly, I would look at, if I analyze the case for me as I was looking at it, it has, if you look at each part of the case and the stakeholders, it presents a changed scenario. If we go by the case itself and the decision, it then means you need a different form of public service. You need a level of independence of the particular officials, and you actually then need an understanding of the stakes at all levels, at executive level, at ministerial level, and also at administrative level.
Good.
But what it does, it creates the committees. I was looking at the committees and the level at which if you read some of the reports, for example, you would find that the committee members are claiming that they were never trained. I think there's a call now in terms of any committee and a clear stipulation of the terms and conditions, so that you get into those committees with your eyes open and the implications thereof. So it has a good side, but also it has a problematic side. Some of the colleagues have spoken about the labor relations implications. And for me, I was just reflecting on the fact that we had to show cause in terms of what were the actions taken to those who seem to have caused that particular expenditure. And sometimes it's not them, it is the delays, it's delays in the systems. So you need a clear due diligence for you to be able to implement the consequences coming from the court decision. That's my take.
Thanks very much. Thank you, Advocate. Helen, any thoughts? And I was thinking Martin Metforth raised some interesting points. Now, Martin is in the UK. I don't know if he's still online, but he did put some points in the chat. Martin, if you think they're worthwhile talking through a little bit more, welcome to come in.
Yeah, so
Morning.
Morning. So yeah, a totally different risk landscape profile, obviously, in the UK. What I would say, though, is it's not risk-free by any manner of means. There are certainly elements of corrupt practice, even if it's indirect. Well, I can do a mate a favour type approach. We saw quite a lot of allegations that may well have happened around COVID procurements and things like that.
Correct.
However, at the moment in the UK, we've got nothing like this. So in other words, I do think this as a judgment is quite critical, because it puts the onus back where, quite frankly, it needs to be, which is on the individuals. At the moment, if people do something, yes, they risk losing their job. And yes, in theory, they risk confiscation under elements of fraud regulation. But what might be described as peripheral stuff, the stuff where actually there is no direct benefit but perceivable in terms of dollars in the pocket, the UK at the moment, we don't have that. So even if we can prove intent, however, that said, we all encourage people to create risk registers, and one of the things that we've seen emerge in the UK recently is the concept of a risk register around conflict of interest. Right. Where effectively, in the old world, yeah, people would be almost told periodically. I get a sort of, can you update your conflict of interest statement, and like annually or what have you. I have to say, you know, whether or not my wife's a director of a company, you know, that sort of stuff. But effectively, that would then be impact assessed. And obviously, in 97.3% of chances, there are a few questions asked beyond that. So we get that, but actually, what we're seeing now is a tendency to say at every stage of the procurement, there is a duty to flag up concerns, first of all, at a personal level, that if there is a sense that something changes in my life during a procurement, where I say, well, actually, I need to point this out and I need to put it on the risk register. But equally, there is an ongoing duty for, almost as it were, on a fortnightly basis, for the person running the procurement to say, okay, has anything changed in the things like the makeup of the evaluators, who's evaluating, and if anybody is does come into an evaluation, what are their interests, what they might be, and also could there be conflicts arising from failure to maintain non-disclosure walls and things like that. So all of that's there, but actually to see it put starkly out that actually if money has gone the wrong way, and bear in mind, I can't see that if the money has gone the wrong way, that procurement and the contract which resulted from it could ever represent that true value for money, because there's money in the system that shouldn't be there. But however, my flip side is, if you do create something around collusion, collusion is notoriously difficult to prove.
Yeah.
Yes.
And equally, the minute you bring the collusion issue out of the box, what you're also doing is you're basically saying anybody who has even the slightest inkling that something might have been going on could in themselves be found to have colluded. We've seen it with the recent resignation of the Archbishop of Canterbury, nothing to do with procurement, but you know, we've seen that, and that was under pressure.
Yeah.
And you know, all of that sort of stuff. Well, yeah, he may or may not have been aware. We don't know the depth of awareness, but either way, he didn't manage that awareness correctly. So and therefore, actually, the minute you actively manage it, you're encouraging collusion, because you're actually starting to say, well, look, how do we all protect ourselves against what I've always said with procurement? Procurement is there to actually defend the innocent in many respects. So where procurement officers or business people have made judgments, you do it in a way that hopefully will not get into the papers as being a corruption collusion issue. So very, very complicated world, this, but actually really quite interested to see where this one goes.
Appreciate it. Thank you. Helen, three things, and then we can wrap up. One is any comments on the comments that have been raised. Two, what is the implication of this for the Public Procurement Act? And three is just to summarize again what you suggest officials should do. Any comments on what's been said so far?
Hopefully I remember all three. Firstly, please do not be alarmed. Please be the voice of reason in your organizations. First of all, this case was about corrupt officials.
Yeah.
Secondly, for good officials, we should have a consequence management mechanism that align your management and treatment of irregular, fruitless, and wasteful expenditure with your consequence management. so that there's a process that everyone agrees to and work to, and officials feel protected. Thirdly, on the Procurement Act, I haven't worked through it in detail now again with this case in mind, but I think, Sean, when the regulations are published, we should provide more clarity, even in the regulations, on ensuring that your labor processes, your disciplinary processes, your financial misconduct processes, and your irregular, fruitless, and wasteful expenditure, all those processes are aligned. And proper guidance is provided, if that makes sense. Thanks, Sean.
Thanks, Helen. That's a great summary. Thanks, everybody. Let's wrap it up. We're over an hour, and really appreciated Helen's input there. Nice to see she's got a team behind her, and yeah, any thoughts that you've got, Helen, on the applicability of this to PFMA? I know there would be a lot of interest in just getting your perspectives on that. You are familiar with the PFMA as well, so please, if there is anything, that would be welcome.
No, I'll definitely send you a note. I know I've prepared a position paper on this some time ago. I'll just have to go back into my archives and find it, and I'll share it with you.
Thanks very much. Thanks, everybody.
Thanks, everyone.
Thank you very much, Helen. Quick heads up, next week after next is going to be a discussion on professionalization. So really hot topic that's happening, and yeah, I think that's going to be an important one. Thanks, everybody.
Sean?
Yes, hi, who's that?
It's me, Advocate Nzaluma.
Yes.
Before you close, can I raise the issue I've been consistently raising regarding the due diligence of regulations? It is important, Sean, that with all these cases, that when then we work on regulations, we then need to step back, which is something that we almost tried with the legislation. Because we need then to say, how does this piece of legislation deal with this particular case? How do we avert this
in future?
And unfortunately, and I want to say it's unfortunate, that with the public procurement bill, we could not get a presentation that actually looks at all the salient issues that were coming from each of the cases. But I'm hoping and praying that we don't miss that with regulations.
Good point.
If I may on that one, Sean.
Because the reason I'm saying this is that when you go to the CAB memo for approval, there are implications for, what are the implications for the posted fleet of an organization? When you look at implications for training, implications for marketing, we need to make sure that that due diligence is done, so that if there are implications for capacitation that flow from the cases and the regulations that aim to address those be addressed as part of the non-negotiables for the regulations to go through, not to think about them when then you are having issues with cases. Thank you.
Thank you. Helen?
Sorry, I think just on that point, which is a really good point, and that's something maybe those of you that have the ear of National Treasury, that when they design the regulations, it would be a good idea to maybe have a register of all the case law and guidance provided by the judiciary in implementing procurement, because that may guide us in writing proper regulations that do give guidance as provided by the courts. So that may be something that National Treasury can consider having.
Maybe National Treasury should appoint you to put that.
That was not lobbying. I just thought it was a good idea from Gloria, actually.
Yeah, but at the appropriate fee, Sean.
Yes, yeah, exactly. Thank you, Martin.
But you know, Sean, let me close it by saying, because I've been practically involved in these processes, even if Treasury does that, for me, the people who must talk to it are the people who certify the regulations. They must actually go. I agree, Treasury as a developer, they must do that. I mean, it's a normal analysis that is done in any institution. I mean, in the military, we've been doing that.
Yeah.
But the institution, which is the state attorney that certifies regulations, must be the one then to say on the basis of this case and this one and this, because they are the custodians for certification. And that is where we need to make sure that the tying happens. Because if it's not happening there, regardless of what Treasury does, they would not have, they don't have authority for that matter to do certification. The people who have that authority is the state attorney. That must show cause then that all those cases and the unintended consequences have been prevented as in terms of early warning in the regulations. This is the point I'm raising. Because I know Treasury does the analysis, but it's not helpful if you say, yeah, the only ones that do it. The analysis must be done by the certifier when they make a statement as to why they've certified these regulations as meeting X, Y, and Z. Thank you.
Good one. And so ourselves and civil society need to be pushing Parliament, National Assembly, and the NCOP to make sure that they're putting the pressure on the state attorneys to come back and say they've done that, they've gone through the cases, and yes, it addresses these issues. Good one. Thanks very much, Helen.
Thanks.
Thank you all. Good one.
Thanks all. Stay well.
Thank you.
Excellent.